Hi everybody, Nancy Beauvert here with Agape and NEXsteps. Welcome back to the channel. Today I am going to talk to you about estate planning again, but this time I'm going to talk about the emotions around that. A lot of times when we talk about estate planning, we talk about it in a very clinical way. We talk about it in a very sterile way. We talk about the processes, the documents that are required, the execution of the distribution of the assets when the time is appropriate. But we never ever talk about the emotions that are involved. And there are emotions involved. Unless you have hired a third party, an uninvolved third party, such as a trust company or a lawyer, an accountant, somebody like that who is not really emotionally involved in the actual life and the estate of the deceased person, you're going to have emotions. That's the very human reality of dealing with the estate. And often we just brush that aside. We're busy telling people, as I say, we're busy telling people the processes. But how do you deal with the emotions? This episode and the article this week on my website is about dealing with those emotions. And it's crucial that we do pay attention to those emotions because, first of all, it's what makes us human. But secondly, by acknowledging the fact that there are emotions involved, we can potentially avoid some complications in the process of doing the execution of the estate. So by acknowledging our emotions, first of all, what it does is it can provide for more and better open communication. Most of the time what happens is somebody will name a family member to be the executor of their estate. And that family member, whether it's a child, whether it's a partner, whether it's a spouse, regardless of who that family member is, there can be a lot of difficult emotions, difficult family dynamics, all wrapped up in that choice. Maybe if you've named a child, maybe some of your other children are resentful of that. Maybe you've gone a step beyond that and have engaged the services of a close friend. And that has its own emotions. You probably thought you were doing a good thing by doing that, but there may be resentment from the family members about why you chose that friend instead of them. So to address the emotions and to be open about the emotions among all of the people who are left living, who are involved in that estate, you can hopefully try to mitigate some of those issues. Now I know that's kind of pie in the sky in some cases. In some cases, you maybe will not be able to resolve those feelings of resentment by having open communication. But it starts there. Now there are things in the processes as well of dealing with the estate and the settling of the estate that it is very important that you continue to communicate. All of the people who are named as beneficiaries do have the right to have an idea of the timeline. Now, again, make sure that you are setting proper expectations when you're communicating this, because there are a lot of things to do when you're settling an estate. And they will nearly always take longer than you thought. It starts with just the probate process itself. To get the grant of probate can take sometimes months, depending on how backed up the courts are, depending on how quickly you can get the documentation together as the executor to present to the courts, or to the lawyer, if you've engaged a lawyer, to the lawyer to present to the courts, so that you can actually even apply for the grant of probate. Then, of course, from the time the grant of probate is applied for, it can take some time for the courts to get to that. Also, there has to be a notification given when the grant of probate is being applied for. And that gives any of the people who are beneficiaries the opportunity to respond to the process. Then there's a whole issue of creditors. You have to post a notice. You have to give an opportunity for creditors to come forward. Then there's the whole filing of taxes. And here in Canada, there are probably at least three filings that you're going to have to do. Depending on when the person passed away, you'll have to do the income tax filing for their last year of life. You'll have to file the tax return for the year of their death, and you'll have to file a final return because presumably you're going to have some investments that are going to be income producing, and that has to all be accommodated as well. And then keep in mind that the executor is legally responsible if they distribute any of the assets of the estate before everything has been cleared off. If a creditor comes out of the woodwork and the assets have been distributed, the executor can be liable for making that up. If you don't have a clearance certificate from the CRA, then the executor could be liable. Make sure that the beneficiaries understand that you can't be held responsible for timings that are outside of your control. So to address the emotions allows you the opportunity to share those experiences with the rest of the beneficiaries of the estate and to hopefully open up that communication. Many of you know that I am a legacy and lifestyle planner, and I'm also a certified executor advisor, which gives me a unique insight to be able to help you along this path. So please hop over to my website. You can check out my credentials. You can also please check out this article to get a few more tips and hints. And if you need an intermediary, if you need a neutral third party, if you need a co-pilot to help you with your role as the executor of somebody's estate, if you need some help preparing documents for yourself or your loved ones need some help preparing for this transition, please, again, just reach out. Thanks very much for joining me on this topic. I look forward to sharing more with you next week. Bye for now.